Hello, it's Mark Oberti and Ed Sullivan back with some tips on how to avoid employment law disputes. And we're on to the FMLA today. And so we're going to kick it off. And Ed, why don't you tell us some of the things that you've seen under the FMLA that might be helpful for companies out there?
Sure, for sure. The FMLA was a statute passed by Congress in 1993, and it stands for the Family and Medical Leave Act. And essentially, if you're a company with if you employ more than 50 people within a 75-mile radius, you're going to be subject to the Family and Medical Leave Act. And one of the big things that comes up in the FMLA is who qualifies for an unpaid leave of absence. Essentially, the law provides a 12-week per 12-month period unpaid absence for employees who work for companies of a certain size. And so what we see a lot of times in FMLA cases is, employers want to know, well, who's eligible for that? And really, of course, a lot of people know that for the birth of a child or for adoption of a child, and then there's a serious health condition. If you have a serious health condition or, a family member has a serious health condition, it would also apply if you're going to care for that person. But what is a serious health condition rises a lot of times, and this is where companies, I think, sometimes get into trouble. They want to guess as to what the employee is allegedly suffering from, or they want to become medical doctors.
Yeah, and our best advice on that is, here's the bright line rule for today, is if somebody just calls in sick, not a serious health condition, clearly, and there's lots of case law that says that. On the other hand, if they tell you a little bit more, that they're going to be out more than 3 consecutive days and they're going to be seeing a doctor and they might be in the hospital, anything that teeters past sick in a significant way, what you want to do then is send out your employer's response to employees' request for FMLA leave, and there's a form the Department of Labor promulgated. It's attached to your appendix. You send that out to them, and they have 15 days to provide certification of a serious health condition. During the 15 days, don't fire them. It's conditionally approved, but if they don't get you that form back and it shows that there's a serious health condition, well, then after the 15 days, they're not covered by the FMLA, and so you have some clarity there. If you don't do that and you just kind of guess as to whether or not they have a serious health condition, you guess wrong and you fire them for not coming to work, well, that's where we see a lot of employers winding up in court in trouble.
Another issue we see is, and it's a pretty simple concept, but it gets difficult in the details, is how much leave does an employee get per year? And really, the reason that becomes a problem is the law provides employers with 4 ways to essentially make a determination on how to start counting an employee's 12 weeks of unpaid leave. You can do it on a calendar year, or from the employee's date of hire, or from a 12-month period, what they call a rolling period, on a couple of different ways of doing that. The issue here is if an employer does not pick a way in the way they do it, then Mark, what does the law say?
Well, the employee, after the fact, after they've been terminated and consult with able plaintiff's employment law counsel, gets to come back and pick the way that would be most advantageous to them after the fact. So you don't want to be at the mercy of the person you fired and who's suing you to then decide what is the best way to measure the year, because you better believe they're going to find the way where you're held liable. And so you want to be very clear about which one you've selected, and you want to put that in your policy and apply it across the board.
Another thing on the FMLA, which is a shocker to I think a lot of companies out there, is if you go back to what we said in the last couple of PowerPoints, it's real bad for companies to promise anything more than they should in employee handbooks. Not because it's not the right thing to do, it may very well be the right thing to do. Just legally, it puts you in a kind of an awkward spot if you don't do what you've actually said you're going to do in a handbook. And one of the things that employees might think you will do is provide them with FMLA leave, if you've in fact promised them FMLA leave. And a lot of times, because there are technical requirements of the 50 employees and the 75-mile radius, a lot of times companies aren't actually subject to the FMLA at all, yet they've, for one reason or another, promised their employees that they're going to be entitled to that FMLA leave. Well, Mark, why don't you tell us about a Fifth Circuit case on that exact point?
Yeah, there's a Fifth Circuit case called Minyard, and the plaintiff in that case worked at an office that didn't have 50 or more employees in a 75-mile radius. So even if the company itself did, her office didn't, and that's what the FMLA measures its eligibility by. But like Ed mentioned, the handbook didn't draw a distinction, and so when she went off on FMLA, or what she was referring to as FMLA, the company actually under its handbook endorsed the notion that she was off on FMLA, and then only after she was ready to return to work, they said, oh, by the way, we just realized you were never covered by FMLA in the first place, so you don't have any rights under the FMLA, you're terminated, and we replaced you. You can imagine that sort of after the fact pulling of the rug out from the plaintiff, drove her to the waiting arms of a plaintiff's lawyer. He was there to save her, and it went up to the Fifth Circuit Court of Appeals there in New Orleans, and they said, you know what, even though really the company wasn't covered by the FMLA, through the representation to her that she was, we're going to apply something called equitable estoppel, meaning that they're now barred from reneging on what they had promised her in the first place, and therefore she does have an FMLA claim. So the message is, if you communicate with folks on FMLA issues, be really super accurate in the communications, and if you find out you're wrong, fix it immediately. Don't wait until after they've relied on it.
You know, and just for readers, they can follow along, for viewers, they can follow along this presentation on our website, www.osattorneys.com/presentations. And not only will you find this PowerPoint that we're sort of going through in a series, but also you'll see a tremendous paper in PowerPoint on the Americans with Disabilities Act, as well as the Family and Medical Leave Act, which have been our last two topics that we've sort of given a brief overview of, but you can really learn a lot there. And Mark actually drafted both of those. You can also see a paper I wrote on the Fair Labor Standards Act, which is our next employer pratfall, which is non-compliance with the Fair Labor Standards Act, which is the law that was passed during the Depression to essentially regulate the minimum wages and maximum hours that employees around the United States have to work. It mandates time and a half of a regular rate for hours over 40 in a workplace. It mandates a minimum wage. And what you'll see is this law sort of, lay dormant for many, many years until about the last decade. Now, if you're an employer and you're watching this YouTube video, at some level you understand that this issue is out there. Almost every industry, every size company, no matter how many employees they're employing, have faced this issue at one point or another. And I think that it's real important to know that if you've not done anything and you're an employer, you're somebody actually watching this video podcast, and you've not actually looked at your job descriptions, what your employees do, and evaluated whether or not they should be receiving overtime, well, you're going to get eventually that question brought to you in a lawsuit.
Well, what about Ed just saying, hey, this is the way we've always done it at the company, the receptionist never got overtime, or this person never got overtime, and that's just the way we've always done it, and everybody does it that way in our industry. Isn't that a good defense?
It's not a defense at all, and a lot of companies try that. Or they'll even say, well, not only does this person, having never historically received overtime, but no one in the industry gets this type of overtime either. Well, that doesn't matter. The law has very sort of set requirements as to, in fact, it says everyone gets overtime unless you're exempt. There's certain exemptions that are out there, many of them, in fact, under the law, but it's the employer's burden to establish the exemption. So, in other words, it's not like some normal case where the plaintiff is alleging discrimination or retaliation, where ultimately the burden of proof on the ultimate issue is up to the plaintiff. Now, that may be true in this case. An overtime case is the burden of proof is up to the plaintiff to show, but really, most of the time, the case hinges on whether or not the employer has properly established under the law an exemption to the overtime requirements. And if you didn't ever look at a study or do anything, and all you in fact did was just sort of rely on the fact that the position has always been one that didn't pay overtime, that's not going to be a defense. And in fact, it may actually hurt you for not doing any type of affirmative review of your positions, because then a lawyer will argue that it's willful violation, and that that would extend a statute of limitations period. So I think, Mark, really it's important for any company who hasn't really done this to look at their workforce, look and come up with accurate and complete job descriptions for those jobs, and then analyze it. It doesn't have to be us, obviously, but talk to a lawyer, someone who knows what they're talking about with respect to
It has to be us or someone equally as competent, which is basically us. No, I'm just kidding.
Well, I mean, how important do you think is an audit?
I think it's big importance. Obviously, the FLSA, as Ed hit on, kind of the main area of cases you see are the exemption issues where a class of employees has not been paid overtime and they sue, say they should have got overtime. But beyond that, there are a multitude of different legal theories that plaintiffs' lawyers can come up with under the FMLA for different distinct sorts of violations outside of just that.
FLSA.
I'm sorry, the FLSA, right. And so for that reason, I think it's a great idea to scrub it out before somebody sues you.
All right, and then, you know, when we look at cases that are out there and that are, you know, sort of hot, what you'll see is that plaintiffs' lawyers, you know, they kind of hit industries all at once. You know, at one point the construction industry was hit in large measure because the allegation was that the persons essentially that were employees for the construction industry, the company had classified them as independent contractors. Well, the FLSA has a very broad interpretation of an employee. It's difficult to establish that those folks are actually independent contractors, and those industries were getting hit for a long time. Computer industries were getting hit for a long time. Anyone with like the word assistant, I mean, you know, they usually get hit in some type of lawsuit, and it becomes, you know, problematic. And I think Mark can talk about sometimes companies know that they've misclassified people. They'd like to reclassify them. They'd like to change the rules, but that becomes a problem too because there's a lot of, you know, issues involved with reclassification.
Sure. For example, you know, let's say you realize because you've hired a lawyer to do an audit that you have a group of employees that are misclassified. Well, sometimes the client might say, well, why do we want to kick a sleeping dog, so to speak? Let's suppose you tell them all of a sudden, hey, we're going to change you, you're all going to get overtime now. Well, it doesn't take a rocket scientist within that group to realize that maybe they should have been getting overtime the whole time. They go to a lawyer, and now you've actually created a problem when you were trying to solve one. And so that's a common problem, and we have some solutions for you on that. And there's several different ways to go about it, but a lot of times it hinges on good communication plan, rolling things out in just the right way. And sometimes, depending on the circumstances, everyone is different. You might want to go ahead and get ahead of the issue and have folks, as part of the reclassification, write down the number of hours that they've been working, because you probably haven't been tracking them if you've been considering them as exempt, and making some payment, depending on the circumstances, at that time. And a lot of times we find that takes the wind out of the sails for any future lawsuit in that circumstance.
And even if you do all that, it still may not completely insulate you from an employee going to a lawyer claiming that you underpaid them or they were entitled to more money. But as long as the company looks and frankly is acting in good faith, trying to solve a problem that's existing, a lot of times you'll see employees will give the company the benefit of the doubt, not go ahead and try and sue after that.
Yeah, it's definitely it's a risk management tool. Doesn't resolve all potential liability, but we've used it with clients over the years, and oftentimes to pretty good effect. I can't think of one time yet where it's just kind of blowing up and the sleeping dog thing has occurred.
So with that, with these two tips, one on the FMLA, the other on the FLSA, that wraps up tips 7 and 8, and talking about the top 10 mistakes made by employers. We thank you for your time.